All right, then let's go ahead and go on the record. This is FM 20 6645 in the matter of the marriage of Whittaker and Whittaker. We are proceeding today by remote proceeding. We are on Zoom and YouTube. And let me take attorney announcements for the record.
Michelle Locke on behalf of Laci Whitaker, the petitioner. We're ready to proceed.
Thank you.
Good morning, Your Honor. David Kazin appearing on behalf of the respondent, Rusty Whitaker.
All right, let's begin with opening statements. It looks like everyone's here that's supposed to be here. And I don't know if there's anybody in the current platform that doesn't need to be here, but I think everybody that's supposed to be here is. Is that correct?
That's correct.
All right, then proceed on opening statements.
Thank you, Judge. Good morning. We are here on a final trial in this case that involves 3 minor children. They are wonderful kids, and my client has been the sole care provider for these children since Dad was arrested on June 1st, 2023, out of pending charges out of North Carolina. Dad had at the time 6 pending felony charges in North Carolina relating to, including the evidence is going to show that those charges were dismissed by North Carolina when the federal government indicted him on a 3-count indictment. He is currently in federal custody awaiting trial on the federal indictments. 2 of the charges involve a minimum sentence of 10 years to a maximum of life. And there's a 3rd charge as a much lesser range of punishment. One is the promotion and production of the evidence is going to show that Mr. Whittaker likes, and my client will testify to this, when they first started dating, he indicated to my client that he only likes girls that are 5 foot or under. And when you see the pattern and history of Mr. Whittaker, what you will see is he clearly likes women that look like children, and you will see the comments he made to my client throughout the marriage that seem offhanded to most people, but saying she looked like an old woman and things like that feed into who he actually is. We are here today because we can't come to an agreement on any of the terms. Mr. Whittaker today is still asking for joint managing conservatorship of 3 minor children, which baffles me considering he is in the current state he is in because of his own actions. What the evidence is going to show is that he chose to miss a recital of Desi on the particular weekend that he went to North Carolina to go allegedly, because he chose to do that as opposed to to watch his child's recital, even though he knew at the time that my client was supposed to be out of town for a long scheduled wedding that she could not get out of. And so he chose to go to North Carolina. He chose to lie to my client about where he was going. And in fact, he told my client that he was going to the Tim Tebow program meeting, and the Tim Tebow Foundation is for the MVPs, which are the most valuable persons. And he helps people that are trafficked, orphans. His focus is to help the people that need help the most. And so what's interesting is he actually showed up at this Tim Tebow revival and then proceeded to go to North Carolina to meet up with this girl at a hotel and engage in criminal activities with her. He was incarcerated in Travis County Jail from June until he was transferred to Mecklenburg County in North Carolina to face the state charges. While he was in Travis County, he was prohibited by Travis County facilities from talking to the children because he was facing charges relating to abuse of a child.
Your Honor, I don't normally object to an opening, but there's quite a number of items that Ms. Locke is talking about that I don't think are going to, I can't imagine they're going to be evidence. They're hearsay, and they're extra evidentiary for under the rules. They're just simply not anything that this court can receive. And so, to the degree she's remarking about comments that she personally may have received from.
I think right now, I do think the the comments about what the Travis County Jail did or didn't do, unless you have evidence of that, let's just move forward. I mean, I think some of that's just,
Well, and we
I,
do have
you,
evidence of it from his own
well, then
statements, from
just,
Mr.
then,
Whittaker's statements.
all right, well, we'll see. But if you'll just try to keep it between the 40s. Evidence is going to come in. I think I have a sense of what this case is about.
Sure.
What are you, with that background, they're still married. Is that correct? The parties
Yes,
are
Your
currently
Honor.
still married.
Correct.
And so now talk to me about what you're asking for with regard to your proposed relief.
Sure. And Judge, so that the court is aware, and this will come into evidence, there's an agreed final protective order in place against Mr. Whittaker on Miss Whittaker's behalf due to conduct that Mr. Whittaker engaged in, including mounting a Nest camera outside her bedroom window without her knowledge and consent prior to their separation. That is the incident that actually led to their final separation when she left the residence on November 23rd, 2022, because she discovered the Nest camera, which he confessed to posting and showed her the Nest Cam account that he set up for a different email to go to. And then she discovered that on November 22nd, and that's what the evidence will show. So I think it's important for the court to understand it's not just there's some allegations relating to criminal acts relating to a child. He committed offenses that related to my client as well. And because of the offenses that he's committed and because of the detriment to the marital estate, which includes he lost his financial advisor's license. And so the evidence is going to show they had to immediately sell his business, and they sold it for less than what it was valued for on the bottom range because they had no choice. In addition, they had to sell their house in Spanish Oaks because they couldn't afford it because that's just based on Miss Whittaker's income because Mr. Whittaker was in jail. And so I say all of these things because it goes into why we are requesting what we are requesting. The evidence is we're asking for sole managing conservatorship. We're also asking for divorce on fault grounds, Judge. We're asking that the court find that Mr. Whittaker engaged in cruel treatment towards Miss Whittaker that rendered further living together insupportable. We are asking that the court make specific findings that Mr. Whittaker engaged in a history or pattern of family violence prior to the filing of the divorce, and the court take that into consideration when it comes to the conservatorship of the children as well as the restrictions on rights and duties that we are requesting. We are requesting that there be no geographic restriction on Miss Whittaker, that she can reside anywhere within the continental United States, so long as Mr. Whittaker is still within the continental United States. We are asking that the court limit his right to attend school activities, field trips, and school lunches, and to only be permitted if by written agreement of Miss Whittaker. We have real concerns about, and I think the evidence will show us what's actually going to happen with Mr. Whittaker because of the pending federal charges, how long his sentence may or may not be, then the restrictions that will be imposed. We're asking the court deny their specific relief as it relates to Mr. Whittaker and his contact with the children because they're asking for a bunch of what ifs. We don't know what facility he's going to go to next. We don't know what the rules and requirements are. The evidence is going to show that the federal system has a limit on minutes per month that each prisoner is allotted. Can you not hear me, Judge? I can't hear you, Judge.
I don't know. Can you not hear me now?
I can hear you now.
Okay. I was going to say you're also asking for a bunch of what ifs, though. If we really wanted to wait and know the playing field, we'd wait until after Mr. Whittaker's criminal trial happened or criminal sentencing happened. You're trying this case from your point of view with a lot of unknowns as well.
Correct. That is not incorrect, Judge, but I do think that what we are requesting, even though there are what ifs, are necessary for the protection and welfare of the child, given the current circumstances. If by some miracle Mr. Whittaker is able to get out of these charges, then he's more than welcome to petition the court. But at the current circumstances, it is not in the children's best interest, and I think our what if requests are appropriate given the circumstances. We have offered, Judge, we have offered that he have periods of electronic communication. We are asking that they strictly be limited to Sundays. I think their request is for more than that. We are asking the court to take into consideration that I guess he is intentionally underemployed by his own actions and pay the child support in accordance with what his earning capacity would have been. We understand if the court will deviate from that based on his current situation and earning abilities. That being said, based on the sale of the business, there is income coming in that can be attributed to Mr. Whittaker. One of the big asks we are making, Judge, is that the court set aside from his division of the marital estate a portion for prepayment of child support because of his circumstances. Because we need to ensure at the end of this trial, what is most important are there available resources to support these children, taking into consideration what may occur with Mr. Whittaker. And with that, that's why we're asking for the prepayment of child support. He has a life insurance policy. We're asking that be maintained while he's incarcerated and through the time of his child support obligation ends in order to ensure there's something left for the children. We are asking that it be continued that Ms. Whittaker not have to disclose her personal contact information to Mr. Whittaker. That's contained within the protective order. And we ask that there be a finding made in divorce decree as well that she does not have to disclose her information. In this case, Judge, and this is probably the first case I've asked for such a disproportionate division, but we are asking for a 70-30 split in this particular case because of the facts and circumstances, because of the waste claims that have occurred in this case. Mr. Whittaker, on just his criminal defense fees, the evidence is going to show has spent $150,000 on a situation that he alone created and he alone caused, and that has drained the marital estate to that tune, in addition to his bond amount that he paid to bond out of the North Carolina jail, only to be picked up less than 6 months later by the feds. And so we ask that that be attributed to him as well, and that Ms. Whittaker be reimbursed for those, and those be assigned to Mr. Whittaker as an asset on the spreadsheet. But we ask that the court take into consideration some of the standard reasons for disproportionate division, including fault in the breakup of the marriage, the party to whom primary conservatorship is granted. And this is going to be an unusual case for the most part because Mr. Whittaker is not going to be able to exercise possession or access for a period of time. And I think the evidence is going to come in. The trial is not supposed to be until this summer. And if that's the case, if it actually goes, then she is the primary caretaker. She has been a sole primary caretaker of 3 very young children while maintaining a full-time career. And the court's going to hear evidence from Ms. Whittaker that she cannot maintain the level and caliber of work that she has done by herself with 3 young children. And so it's going to affect her earning ability, which is why we're asking for a bigger disproportionate division of the marital estate. We believe also that Mr. Whittaker has breached his fiduciary duty to Ms. Whittaker. He was a financial advisor and managed to ensure that all of his separate property remains separate on his summer retirement, but then ensured that Ms. Whittaker kept adding to her separate property fund, which commingled it, creating a tracing problem for the estate. But we believe with his knowledge as a financial advisor, he was aware of those things and did those things intentionally. We've asked for a wasting claim, and I think that relates to the expenditures that he has had, and as well as we've pled for invasion of privacy that related to that Nest Cam that he put up. We've also asked the court to confirm my client's separate property as we have set forth on the spreadsheet, and we're asking for an attorney's fees judgment against Mr. Whittaker. It is my belief that given the circumstances in this case, this is a case that should have been settled long time ago, but we believe, and I think the evidence is going to show that Mr. Whittaker is doing this solely to punish Ms. Whittaker, and he's not looking out for the best interest of the children, that he solely wants to minimize what is available in the marital estate. And I think the court will see from some of the expenditures what has actually occurred. I think they're going to make some claims about my client that are some assertions that Ms. Whittaker said he was a good dad, and so he should be a joint managing conservator because at one point there were Father's Day cards and Facebook posts that showed what a wonderful dad he was. And I think that was all prior to his arrest for the current charges, because boy, does that change the nature of things, and my client will testify too. We are asking for an extraordinary amount of relief in Ms. Whittaker's favor, and this is I think probably the first time in almost 23 years that I've made such a big request, but I think the facts and circumstances in this case warrant a 70-30 split. We believe that's a just and right division of the marital estate, taking into consideration all the factors set forth in the family code. We further believe that the requests we have made with regards to the children are necessary to protect the safety and welfare of the children. Thank you, Judge.
You ready to hear from me, Judge?
Mr. Kazin, sorry, I was unmuting myself. I have some background noise at the office, so I'm going to unmute myself. Also, you'll see me looking up and off to the side. I'm just looking at your pleadings in this case. It's just the way I have my computer set up. I think sometimes makes it look like I'm looking at the ceiling, but I'm not paying attention. I'm just looking at your proposed disposition of issues and all the filings in this case. So take note. You think I would have figured that out by now, but in any case, I like to leave you on screen while I'm looking at things. Go ahead.
Your Honor, and if I may, I also would like to use, I'd like to illustrate some document, just the pretrials, because I think walking you through the differences, the understandings of how they operate, I think it'll be important so that you don't misunderstand what's there and that you kind of understand the differences.
Sure,
I'm not going to get into
I've allowed you to share your screen, so
Okay,
you have
thank
that
you.
function. Thanks.
First things first, Your Honor. You're quite right. We tried quite hard to get more time under our belt to allow the criminal matters to come to a conclusion so that we wouldn't have to be in this dilemma of so many what ifs. And the result of where we are today puts me and my client in a position that I have to admit I've never been in as a family law practitioner, but he will be taking the Fifth Amendment and exercising his right against self-incrimination as to anything related to pending allegations, and certainly anything of a sexual nature that doesn't relate to his wife or his children. There's also this allegation that's been made that he bought and sold what are called Pokemon cards. He's got a son, Weston, who really enjoys Pokemon and the cards and buys and sells them and trades them, and they play this game together. And now the allegation is that he's been spending time in chat rooms with little children and using that sort of to lure them. There's absolutely no evidence of that, but he may speak to that. But beyond that, he quite definitely will have to take the Fifth Amendment, which he wouldn't have to do if we were able to resolve the criminal matters first. That allows, I suspect. You have a question, Your Honor?
Well, I was just going to say, that's not precisely what I said. I try cases, maybe you never had, but this is quite common in family court, quite common in child welfare court, quite common on the civil side. We almost always get our cases tried before the criminal case because they get reset a lot. And so it's not uncommon for me. You just do the best you can.
Sure.
Your client does have to take the Fifth Amendment if he so chooses, but I hope has been explained that in civil court, unlike in criminal court, that if you don't answer questions and you invoke your right, the judge can make a negative inference against it.
Understood.
And so I think I just wanted to be clear. I was just pointing out to Ms. Locke, as I would point out to you, that we don't know everything here, but that is true in basically, I don't know, 95% of the family cases I try.
Yes,
but
I
just think the idea that we don't know everything, that's just
Yes,
where we are. And it's quite common, actually, this posture that we're in. It's not uncommon at all.
And it may be more common to you than it is to me, but nonetheless, it was our preference to try to resolve the criminal matter first so that we wouldn't be in this position with regard to the Fifth Amendment. And so in that regard, I asked the court to use your common sense, because if Ms. Locke dreams up any manner of multiple questions that would be objectionable just by their very nature, that doesn't mean that all of them are true or that you should draw a negative inference just because she can dream up that many questions. So beyond that, what you're going to learn in the evidence, Your Honor, is that Mr. Whittaker apart from his current circumstance, is an amazing father. He's not just a good father or an excellent father. I rarely have cases with this much evidence of devotion to wife and children and family life. And so you're going to hear about all of that. And what we have now, because I've taken Ms. Whitaker's deposition, is she has rethought of every single instance, even the positive ones, even the ones where she was acting loving and caring, and they were exchanging positive sentiments towards each other, as somehow now abusive. She testified to that in her deposition. So she's reimagined everything, and is quite angry, and so that's why we have these extreme allegations. What I didn't hear in Ms. Locke's opening is very much about the needs of the children. These children, yes, true, they're in a difficult circumstance with an incarcerated parent, but they're still going to have to view the world, make sense of it with regard to each of their parents, and one of which, whom they desperately love. It was the kind of love that from the moment he would get home from work, they would all tackle him and beg for his attention and compete for it. They still compete for his attention. They fight over who got more video time with Mr. Whittaker, who got to spend more time hanging out with him during supervised visits. They still adore their father, and there's been no explanation whatsoever from Ms. Whitaker's side about why cutting off essentially the entire relationship is better than allowing for some modest visits. Our pretrial does ask for the ability for Mr. Whittaker's brother to come and take the children to visit their father. Now, if you carefully read the pretrial, it talks about once a month, probably pie in the sky. I would tell this court that we would like some reasonable level of visitation, whereby Mr. Whittaker's brother can take the children to go visit their father on select weekends, be it quarterly, be it a couple times a year. But Mr. Whittaker's brother will testify, and you'll learn that he's very willing to do this. Mr. Whittaker's brother is very familiar with the children. They have shared close family ties for all times up to now, except for since Mr. Whittaker's brother helped him bond out of jail. And ever since then, Mr. Whittaker's brother is persona non grata, and Ms. Whittaker no longer trusts him. But there's absolutely no reason for that. He's perfectly suitable, has children of his own, and is able to take these children to visit their father on occasion. Now I'm going to share my screen and talk to you about the difference in the treatment of the estate. This is the pretrial that I got from Ms. Locke. Now, you'll see here that Mr. Whittaker's 401k, which was mostly accumulated before marriage, is all there as community property. We have accepted, we'll stipulate right now to their tracing as provided by Sonia Desai, their professional forensic expert. We will stipulate to that tracing. We believe that both sides are entitled to get back their separate property. You will see, and I'll show you the difference on our spreadsheet, but there's a community portion and then there's a separate portion. We will seek to trace that. If we are unable to fully trace it, then we ask that the proper amount be reimbursed, and we can give you those calculations. We feel very confident we have those calculations. I have made in my pleading, you'll see under reimbursement, I've even included the case precedent of the Horlock case, wherein a gentleman came into the marriage with some $900,000 of separate property, built up a community estate to $4 million, had no tracing whatsoever, but was still reimbursed his separate stake. On that basis, the court should reimburse my client's separate stake in both his in his 401k, as well as the proceeds of the house that he had prior to marriage. Those numbers will appear on our spreadsheet. Right here are the constructive fraud or wasting claims that Ms. Locke spoke of. $150,000 to the criminal defense attorney and $25,000 for bonding out. Of course, we disagree with those. My client is, of course, innocent until proven guilty. I understand all about the negative inference if he takes the fifth. However, he's still nonetheless innocent until proven guilty. This third item is purchase of Pokemon cards. And the evidence is going to show that my client, since he was in North Carolina for a while, because under state charges that were pending for a while before the federal charges, he had to stay in the state of North Carolina and he had no income of his own. During that time, he would buy and sell Pokemon cards, just like any trading item, any antique, anything where he could actually try to make money. He was doing that as well. It has nothing at all to do with children or sexuality. Finally, there are 3 accounts that they have. These are brokerage accounts. We don't know why they've got them designated to the children. These belong to the parties and they belong in the community estate. What you won't see in this spreadsheet, Your Honor, is there's close to $900,000 of future payments. Now, here's the net. I'm pointing to it down here. They have a net of $2.2 million. With no indication whatsoever about the balance of the business that's still coming due. The purchaser of Mr. Whittaker's business, he paid some lump sum payments to begin with, and he's still making $25,000 a month payments and will be until 2027. So now I want to shift and talk to you about our spreadsheet so that you'll understand the difference. I'm showing you now our proposed disposition of issues. This is an amended one that I filed last night. I also filed a motion for leave to amend under the local rules because I understand that's required. The first thing I'd point to here, Your Honor, is you're going to see on the right-hand column, the exhibit that goes along with the source documentation for each line item. And so I'm going to go through fairly early and seek to admit all of these wholesale merely to back up our version of the community estate. You'll also see that we have cast as reimbursement claims 3 items. This first item, $385,000, first we're going to seek to trace it bit by bit. And if we're unable to do that, then we ask for it in the Horlock reimbursement fashion. That is out of what you will find above. The full value of the retirement account is actually listed in here at sorry, Your Honor. It's this item here at the bottom of the first page. It's at 501. We've listed it at full value, but are asserting as a negative increment. This is mathematically how we're addressing this and placing that negative item in his column because we think that needs to be pulled out of the community estate before assessing and dividing the rest. This 106 will show evidence is the amount received from the proceeds of his separate property home. This final item is 5% goodwill from the sale of his business, which we believe under the law is arguably separate property. If it's not separate property, it's certainly going to be considered a windfall to the community estate because if he were still running that business, that would be not community value. Now, with regard to their claim for lump sum child support, Your Honor, we don't have any indication of what that number is or ought to be. I want to be very clear, Your Honor. My client in his pre-trials has said he will pay full guideline child support at the top level under the guidelines if he's awarded at least 45% of the community estate. Reason? His whole job, his whole endeavor was making money with investments. He owned a wealth management firm that was quite successful. At one point, their entire community estate, all considered, was north of $4 million. And that's largely due to his efforts. We are asking because what he can do, the use of the money will go so much further if he's given a fair shake in the community estate and is able to invest that money, even if he's incarcerated, and generate the income to pay full guideline child support. He's willing to stipulate and do that if the court does as we ask and gives him a normal monthly child support obligation instead of lump sum. If the court's going to consider lump sum, then I would ask the court to take a look at, I'm going to show the court. This is the wage and salary presumption, which was changed in 2015 by the legislature. Section B was not there before 2015. This is the minimum wage presumption that we're all familiar with. However, the presumption is not even in play if the obligor is incarcerated. I also want to show the court 156.401, which are grounds for modification and support. This is a 2023 addition to the Family Code that clearly states that it's grounds for modification if the obligor is incarcerated. Sum it all up, Your Honor, and we are willing to pay the federal minimum wage guideline calculated out to the youngest child's emancipation as a lump sum if the court goes lump sum. We don't think that's the way to go. We think it's a better thing for the children and for all concerned, because Mr. Whittaker can make money on his money, to give him a decent share of the community estate and let him invest that money and then provide full guideline child support. In the end, Your Honor, Mr. Whittaker needs an opportunity to parent these children. We have every confidence that he will either be acquitted or in short order, he'll be available to reunite with these children. More importantly than what he needs, these children need their father. They need their father, and you're going to hear lots of evidence about that. Thank you, Your Honor.
All right. Thank you. Ms. Locke, you may call your first witness.
The only thing I wanted to clarify, Judge, because it just may change my order of witnesses, is Mr. Whittaker going to be available tomorrow, Mr. Kazin? Did you find out from the jail?
I thought I disseminated all that information. Yes, we are firmly aware that we should have him for 2 days, not just the first. They seem to be quite firm that they would not give us a third. They may change that if the court were to make a special request, but that's what they've told us.
Okay.
Here is my schedule because I can't be available all the time. I have some scheduling issues on my end, including presiding over a ceremony this afternoon at 3:30 of one of my colleagues. And so I think what we'll do, they're on Eastern Standard Time. We're on Central Standard Time. So we are going to go till about 11:30 Central Standard Time this morning, which will be 12:30 their time. We'll take an hour break. We'll come back at 12:30. They'll come back at 1:30 if it works for the jail, because they're being very, if they're listening, they've so far been actually very cooperative with us in making him available. And then we'll probably end about 3:15 today, our time, which is 4:15 their time. And then tomorrow we'll work off that same schedule. I have something in the morning, but I'm going to work on moving that to the end of the day rather than the beginning of the day. And so we can kind of do that same schedule tomorrow. So we don't have a lot of time. Y'all are going to have to be incredibly efficient. Get to the point. Do not beat dead horses. Get to the point, because that's the amount of time we have. That gives you both probably about 3.5 hours, well, a little more than that probably. Gives you both about 4 hours, 4.5 hours probably to put in all your evidence, but you're going to have to be very efficient and very thoughtful about your time, because my plan is to have this done by the end of the day tomorrow.
Yes, Your Honor.
Okay. You may proceed and call your first witness.
I'm going to call Ms. Whitaker, please.
Ms. Whitaker, please raise your right hand and be sworn in. Unmute yourself. Sorry. In the testimony you're about to give, do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Will you please state your name for the record?
Laci Whitaker.
All right. And Ms. Whitaker, what was your date of marriage to Mr. Whitaker?
December 12th, 2015.
And what was your date of separation?
I believe November 22nd or 23rd of 2022.
And prior to filing this petition for a divorce, were you a resident of the state of Texas for 6 months?
Yes.
Were you also a resident of Travis County for the 90 days prior to the filing of the petition for divorce?
Yes.
Were there 3 children born or adopted of this marriage?
Yes.
Okay, and you're not currently expecting a child, is that correct? Okay.
Correct.
And you are asking this court for a divorce on the grounds of cruelty, is that right?
Yes.
Okay, but in the alternative, there is no reasonable chance of reconciliation between you and Mr. Whitaker, is that correct?
No.
And at the end of
That's
this
correct.
trial, you're asking the court to grant this divorce, is that right?
Yes.
All right.
Please.
I'm going to share my screen and just click through some exhibits. You, in this case, have filled out a proposed support decision. Is that correct? That it goes over your finances?
Yes.
All right. I'm going to show you what's been marked as P4, and this is, in fact, your proposed support decision and information. Is that right?
Yes.
Will you tell the court who it is you work for currently?
I work for GE Healthcare
And how long have you worked for GE Healthcare?
since February of 2015.
All right. And what is your average income with them?
I believe I'm a sales rep, so I work mostly on commissions, or the majority of my payout is commission based. And if I am at plan for the year at 100% of my quota, I'm expected to make approximately $220,000 before taxes and expenses.
All right. And is this budget based on you meeting all your goals and objectives?
Yes.
All right. I move to introduce P4.
No objection, Judge.
P4 is admitted.
And so we're clear, are you actually on projection to make the same amount of money that you had listed in this budget?
No.
And what are you currently at a deficit with your company?
Yes.
And what is your current deficit with your company?
Approximately $17,000. I've been overpaid as a result of having to take short-term disability leave to manage the aftermath of everything that's happened since Mr. Whitaker's arrest and since he bailed out of jail. So I was being paid short-term disability, and then I also got paid from our commission pool. That the two hands don't talk to one another, so they've double paid me, and now I have to pay the company back.
And how is it that you pay the company back?
They just withhold my future paychecks until it's paid.
Okay. And what kind of hours were you maintaining prior to the Mr. Whitaker's incarceration?
So my hours are, I'm in sales, and so it depends on my customer. I meet the customer where they are, when they need to be met. So I sell medical equipment. I work with emergency departments, ICUs, ORs, doctors in their clinics, and my territory spans from Waco down to Laredo. So, you know, there are some mornings that I have to be in the OR in San Antonio at 6:30 a.m. There are some evenings that I have to meet with the doctor after he's done with clinic during the day to do demonstrations and installations and things like that. So my hours are different every single day. My office is at home, so there are some days that I work from home, but you know, other times it's early mornings, it's late evenings, potentially with some flexibility.
Okay. And you've also, in this case, I'm going to show you what's been marked as P8, and we'll go back to your work in just a second. This is your proposed disposition of issues that you're asking the court for relief on in this case. Is that correct?
Yes.
Judge, I move to introduce P8.
I hear no
objection.
objection. Okay, yes, P8 is admitted.
Thank you. And this is your proposed property division as P9 that you have filed with the court. Is that correct?
Yes.
And that's where you're asking for a 70-30 split. Is that right?
Yes.
All right. Judge, I move to introduce P9.
No objection.
P9 is admitted.
And I'm going to show you what's been marked as P3, and this is the agreed final protective order that was entered into on May 13th of 2024. And you recall this agreed protective order, is that right?
Yes.
Judge, I move to introduce P3.
No objection.
P3 is admitted.
All right. So are you able to maintain the same work level that you were able to maintain prior to Mr. Whittaker's incarceration?
No.
Okay,
No.
sorry. The court reporter can't take us down both at the same time, so I'll do my best to let you finish your answer before I ask my next question. Tell the court why it is that you're not able to maintain that workload.
So there are multiple reasons why I can't maintain that workload anymore. One of those reasons being since June of 2023, when Rusty was arrested on 6 felony counts of statutory rape of a minor in production of child pornography. I have been the sole caretaker of 3 very young children at the time. They were ages 7, 4, and 1. I got the call that he was arrested while I was on a work trip. Actually, I was out of town on a work trip. It was an exciting work trip for a big deal that I had sold the previous year, and I was in Cleveland, Ohio, and I got a call from my nanny who was at my home that the FBI
Objection,
was at our
hearsay.
house. I'm sorry.
Right, he
Objection,
objected to hearsay about the nanny call, and I think that's probably hearsay. So I'm going to, though I don't know if it's really about the truth of the matter asserted, because I don't know what she was going to say. But getting a call from the nanny, not hearsay, whatever the nanny said to her is hearsay. And so ask another question. Ms.
Yes,
Locke.
Judge. Do you
So,
remember
well, I'll
No,
just
ask Ms. Whittaker, wait, have Ms. Locke ask you a question. There you go.
Ms. Whittaker, do you recall the date of his arrest?
yes,
And what was
June.
that date?
June 1st, 2023.
Okay. And do you recall when it was that he, how long was he incarcerated for?
Until the end of February of 2024.
Okay. And what happened in February 2024?
He bailed out. He
Okay.
bailed out.
Did you and Mr. Whittaker have some kind of agreement about whether he was going to bond out or not while his case was pending?
We did not. We had discussions after his arrest, shortly after his arrest, when he was still in Austin, about him bailing out, and we both agreed that he would not, because he was getting time served while he was awaiting trial, awaiting for whatever was to come, and it was also going to be very expensive while he was in Texas because he was on a governor's warrant, and I think we were going to have to put up like $83,000 in cash for him to bond out. So we agreed that it was in the best interest of the children in the estate for him to get time served and get it out of the way while we awaited the outcome of the trial.
Okay. And let's talk about, did you have communications with him when he was first arrested in June of 2023 while he was at the jail?
Yes,
Do you remember that first call in particular?
I do. Yes.
Okay. And what stuck out to you about what Mr. Whittaker told you during that first phone call?
When I talked to Rusty, I asked him if he knew how serious this was, if he had any idea what he was facing, and he told me, "Yep, this is the end."
And did he tell you anything about about caring for the children or anything related to the children?
As far as what?
Who was going to care for them?
Well, I don't know that he necessarily told me, but of course, everything was falling on me.
Okay. And what did you understand when he said it was the end? What did that mean to you?
That was an admission of guilt.
Let's go back to the.
I'm going to object on the basis of speculation, Your Honor.
She asked her for that. I think it was, I'm gonna overrule that objection because that's basically the question she asked her, and it was asking her to speculate, which she didn't object when it was asked, and so then she answered. So I'm overruling your objection.
So let's talk a little bit about the history of your relationship, and remember we have limited time, so let's focus. When Mr. Whittaker first met you, what did he indicate to you about his preference for women?
He told me that he liked short girls,
Okay, and did he give you a specific height requirement?
5'0" or under.
Okay, how tall are you?
5'0",
Okay, and I know this is a rude question, but how much do you weigh?
105 pounds.
How big is Mr. Whittaker?
Approximately 5'10", I believe.
Okay, and do you have any idea of what he weighed at the time what was the last weight you knew him to be?
190, 200 pounds.
Okay, and let's talk about the first time that there was an incident between you and Mr. Whittaker where you felt your personal safety was at risk. Do you recall that?
Yes, I do.
And when was that?
That was likely in 2024 at a wedding of one of his friends.
Okay, and where did that wedding take place?
It was in Mexico.
Okay, can you briefly tell the court what happened, that particular incident that gave you concerns for your
Your
personal
Honor,
safety?
I'm not going to object, but I think we need some clarification here. She said 2024.
I'm sorry, 2014. Thank you.
Can you answer the question now, Judge?
Yes.
Thank you. Go ahead, Mr. Whittaker.
We were getting ready to go to the wedding, and there was an argument, and Rusty threw a phone past my head and put a hole in the wall, and then he left me in the hotel room and went to the wedding of his friends without me, just left me.
Okay. And why were you concerned for your personal safety in that particular incident?
Because the day, it was just so unexpected. The relationship up to this point had been nothing but rainbows and sunshine, and it was just completely out of the blue that he got so angry so suddenly, and that he threw his phone past my head and put a hole in the wall. And then, there's anger, there's bursts of anger, there's maybe kind of like, oh man, I did that, now I need to calm down. But it wasn't just the anger, it was the doubling down on the actions. And, he did what he did in the hotel room, and then he left me. And then it was my fault that all of that happened. And I had to be the one to come back and, apologize for my, that it's a theme in the marriage. Just my reaction to his behavior creates even more conflict, and then I end up having to be the one to apologize for my reactions.
Were you already pregnant with Weston at that time?
No.
Okay. And then you fell pregnant with Weston before you all got married, is that correct?
Yes.
All right. And there was another incident in summer of 2015 while you were pregnant with Weston?
That
Or was that the friend's wedding in Mexico?
was the wedding in Mexico.
Okay. And then what was the next incident after that that gave you concerns for your personal safety?
The next one after that, there was an incident at Rusty's house. I had made him some cookies. He really likes Reese's, and so I had a recipe for a peanut butter chocolate cookie that was delicious, and I wanted to make it for him because I knew how much he liked Reese's. And I brought him some cookie dough while he was out in the front yard tending to his roses. And instead of being happy that I'm making him cookies and brought him cookie dough, he got really angry with me because I didn't even bring him a glass of milk or water to wash it down. It was hot outside, and he got mad at me, which shocked me because I'm trying to do a nice thing for him. And so then it hurt my feelings, and I said, okay, well, fine, don't have any cookie dough. I don't remember exactly what I said, but my feelings were hurt, and I went back inside and I baked the cookies. When Rusty came in from tending to the roses, he was huffing and violently storming around the kitchen, throwing things, and threw away the cookies and all of the items that I used to bake the cookies.
Did he break anything?
I don't know that anything was broken, but it was a startling experience.
Okay. And did you have any of the kids at that point?
No.
Okay. And so was there another incident in 2018 in Las Vegas?
Yes.
And what happened with that particular incident?
We were getting ready to go out with some friends for dinner. We were in the hotel room. It had been a wonderful day up to that point, and I was getting ready. I had on a black dress, red lipstick, and I asked my husband, how did I do? How do I look? And I'm expecting him to say, you look beautiful, darling. But instead, he gave me this stare that was just chilling, and he said, you look like you're going to a fucking funeral.
Okay.
And
why did that concern you?
it was like I had a completely different person instantly. It was frightening because we had shared such a wonderful time together up to that point, and it's just so shocking and unexpected and uncalled for. There was no conflict between us whatsoever. He just kind of, and it wasn't in a joking way. I clarified it. I said, what did you say? And he was very serious. It wasn't a joke. And I thought I was trying to get him to, take it back. But he wouldn't take it back. He was firm on, I looked like I was going to a funeral. And of course I got upset like anyone would. And then he got upset at me getting upset. And again, he threw his phone past my head and put a hole in the wall in the hotel room.
Okay. When was the first time that you called the police on Rusty's actions?
That was in June of 2019.
Okay. And can you tell the court what children you had at that point and what ages they were?
Yes, Weston had just turned 3, and Desiree was a few months old. She was born March 27th of 2019, so a new baby.
Okay. And so what happened briefly that particular day that gave rise to you calling law enforcement?
So that day, we were, a couple months into the newborn phase. We were sleep deprived. I was particularly exhausted because she was in a cluster feeding phase, and I breastfed all 3 of my children, each for a year. And so this was, we had also just moved into a new house in Spanish Oaks. We had no furniture. It was a kind of a stressful time because not only did we not have furniture, but we were painting, and there was, a bug infestation. So it was just kind of like we were all kind of on edge. And Rusty had told me that he was going to take Weston to the golf course that day to give me a break, let me get some sleep, and just be me and Desi for a little bit. So I was napping that morning, and I woke up to Weston screaming in the living room, screaming for mommy and daddy. And I waited a few minutes thinking Rusty was going to come get him, but he didn't. A few more minutes went by, and I got up and out of bed, and I saw my 3-year-old son in the living room by himself. I said, "Where's your daddy?" He said, "I don't know." So I went to look for Rusty, and I found him behind a closed door on the couch, completely under a blanket, like head and everything, hiding under the blanket. And so I'm again upset because he's told me he's going to take Weston out of the house so I could get some rest. Not only did he not do that, but he's now abandoned his son in the living room and expects me to just know that I'm supposed to now care for both children, expecting to have a nap. But so I'm angry. I, said to him, like, what's happening here? Like, what are you doing? You're under the blanket. Clearly, I want him to get up and help and follow through with his commitments. Instead of engaging in a conversation or giving me any explanation, he got up to try and leave the house and just leave. He was going to leave me with the 2 kids and not talk about it, or not, step up and do what he said he was going to do. As he was trying to leave, I said, "You're not going to walk out on us. You're not going to, that's a cowardly thing to do, to leave your family. Like, you're not leaving this house." I believe, as Mr. Kazem will very likely tell the court, that I said, "You'll have to run over me if you think you're going to leave this house." And it got escalated really quickly. And as he was walking out the door, I was following behind him. I tried to, get him not to leave. I had my leg in the door as I was walking out into the garage, and Rusty grabbed the door and slammed the door shut as hard as he could. And I barely had time to move my leg out of the way. He, raised his fist and leaned over me and said, "Shit's over." And at that point, I let him leave, and the adrenaline settled, and I called the police because I was so shaken by the incident. I've got 2 small children who've witnessed this whole thing. I don't want him to come back to the house because I was, the conflict and argument is one thing, but he took it to a level that I have never experienced or seen in my life before. And it made me really uneasy. I didn't want him to come back to the house that day. So I didn't know what else to do. I called the police. They came over, they took my statement. They left me with a bunch of pamphlets about victim services. And they said, "Good for you for calling. Most people in
Objection,
this type
hearsay.
of."
Sustained on hearsay
Okay.
as to what they told her.
Okay.
And
They left
remember,
me with-
Miss Whittaker,
Can
you can only tell me what either Mr. Whittaker told you, and that's it. Anything else I've said, the groundwork for exception, but you can't tell me what someone else said, unless it relates to Mr. Whittaker. That being said, who was arrested that day, if anyone?
Rusty was arrested that day.
Okay. And what was he charged with, if you can recall?
Assault by bodily contact.
Okay. And do you know what happened with those charges ultimately?
Rusty never told me.
Okay. But you were not made aware of any kind of conviction, is that right?
I was not made aware, no.
Okay. So in December 2020 was the first time you filed for divorce, is that right?
Well, actually, after Rusty was arrested, when he attempted to come back home later that day, he was hiding outside the door. I had ordered a pizza because, again, we just moved, we had no food, and he had been gone. I didn't want to leave with the 2 kids, so I ordered a pizza. And when the pizza man arrived at the door, he looked terrified, and I said, "What's going on?" And he turned his head to the side, and said, "Ma'am, is everything okay?" And I looked over and I was looking
Objection,
through
hearsay.
the peephole.
And
It's
narrative.
okay.
Yes,
say-
sustained on hearsay. And I'll go ahead and sustain narrative too. Ms. Locke, just ask another question.
I will, Judge. And so after you had a brief conversation with the pizza man, what happened next?
Rusty, I noticed he was standing to the side of the door, and he said, "Oh, I'm getting in that house." And I said, "You are not coming in this house." And I don't know what to do. The pizza man is standing here. This is incredibly awkward. I cracked the door open to try and retrieve the pizza, and Rusty barged through the door and came in the house. And at that point, I called the police again per their direction earlier that day, and they came and they took him to jail.
Okay. And did he file for divorce at that time?
He did. He spent the night in jail, and then the following day he filed for divorce against me.
And did he seek a temporary restraining order against you as well?
I believe he did, yes.
And what was he seeking against you, if you recall, with regards to the children in that particular incident?
Full custody and child support.
Okay. You all reconciled after that for a brief period of time?
We did, yes. It was a difficult year, but we spent a lot of time in therapy and eventually reconciled.
Okay. And then there was another breaking point around September 11th of 2022. Do you recall that?
Yes.
Okay, and what happened on that particular incident?
That was Julie, our third daughter's first birthday party at Kalahari.
Well, hang on. And who was present at that Kalahari birthday party?
Our entire family. So my parents were there, my mom, my dad, my brother, his wife, their two young children, Rusty's mom, Rusty's brother, Dusty, and his wife, Rebecca, and their two children, Grace and Holly.
Okay. Did you have any other friends, family, anyone else there for this party?
I was there working, I was working an event at Kalahari, a corporate event, a conference. So I had good deals on room rates being associated with the conference, and it was the same weekend of her birthday. That's why we decided to have it at Kalahari.
Okay. And
so
was
yes,
it,
my clients and their families were there as well.
all right. And was there an incident with Mr. Whittaker in front of the family while at Kalahari?
Yes, there was.
All right. Can you tell the court briefly about what happened on that incident?
Yes, we were having dinner down in the arcade in a very public place, sitting outside of the restaurant. So Kalahari is an indoor water park, but they've got the arcade as well as the restaurant kind of all together. So there's the door to go inside the restaurant, pick up your food, and then there's tables that sit outside the restaurant in the arcade area. So we were at a table outside of the restaurant, and there had been some conflict earlier that day between Rusty and my mother, and Rusty was frustrated because I was working the conference and he was doing the heavy lifting for the party, and he felt that he wasn't getting the support that he needed or the respect that he deserved for all that he had done that day. He made a comment to my mother that upset me and my dad said, "Don't talk to my wife that way." And I
Objection,
said,
hearsay.
sorry.
Yes, sustained on hearsay.
Okay.
Ms. Whittaker, you cannot tell me what someone else said unless it's directly from Mr. Whittaker, okay?
I understand. I'm sorry. This is not a language I'm accustomed to speaking. I'll try to do my best.
All right, so your dad made a comment, and then what happened
Yes.
next?
And then Rusty picked up his tray of food and he threw it at me on the ground at my feet, lifted the table, and food went everywhere. And again, we're in the arcade. There's so many people around watching this incident. And he just got up and he left. He left us. He left the mess. He left everything. and he went home that day. He left the entire property.
All right. At that point, did you know your marriage was over?
Yes.
Okay. And what happened next that became the final straw and the reason for you all separating?
So when I made it home finally from Kalahari, Rusty told me that I wasn't giving him enough attention and that we should probably get divorced. And he moved out of the marital bedroom into the guest bedroom, where he was living from September 11th until November of 2022, November 22nd, 23rd, 2022. And during that time, he had installed a Nest camera outside of my bedroom window without my knowledge or my consent.
Okay, well, hang on. Let me show you what we've marked as P35. And this is the actual Nest camera that was outside your bedroom window.
Yes,
And this was after Mr. Whittaker gave it to you on the particular day in question.
after I caught him, yes,
Okay. And you've not changed or modified this picture in any way, is that right?
correct.
It's a true and correct copy of the Nest camera that you received from Mr. Whittaker on this day in question.
Yes.
Judge, I move to introduce P35.
No objection, Judge.
35's admitted.
All right, let's talk. Thank you, Judge. Let's talk to the court a little bit about how you discovered that he was recording you. Can you tell the court briefly what happened that particular afternoon, evening?
Yes, so our home, there's no other homes that are next to ours where the bedroom windows are. So, and it's very dark. There's, light pollution ordinances in the neighborhood. So no lights or anything behind the house. And I noticed that there was a light in one of my windows, and it startled me because there shouldn't be anybody behind my house. And there's nothing back there. So to see somebody walk around behind my house was concerning. So I was nervous, I was kind of looking out the window, trying to stay to the side.
And what did you do next?
Then I saw Rusty outside of my window, and he was scanning the room, and I don't think he could see me, but I could see him. And I said, "What are you doing?" And at that point, I saw him grab something from the windowsill and run. And so I then went outside to try and find him. I couldn't find him. I came back inside and I found him in the guest room, laying on the bed with his hands like this over his chest. And I said, "What did I just see? Did I just see what I think I just saw?" And he said, and this is a quote, "I fucked up. I'm sorry, I fucked up." And so
What happened next?
I made him pull up the Nest account with the video, the recordings that he had made of me. I wanted to see what date the camera had been installed. I wanted him to give me the camera. I wanted to know what email address he had used to set up the account. And so he showed me, he pulled up the account. It had been installed almost 2 weeks prior to that date when I was out of town and on a trip with the kids. He installed it. There was a day period where he was home and I was gone. The email address, he showed me the email address on the account, and he gave me the camera, and I told him this was right before Thanksgiving. So I said, "I'm taking the kids up to my parents in Dallas, Fort Worth for Thanksgiving. And by the time we come home, you need to be gone."
Okay. Was he gone when you got
He
back?
was, yeah. Yeah, he had secured an apartment and he moved that Sunday.
And Judge, real briefly, I know we're stopping at 11:30, but I didn't know we were taking a morning break from Miss Racanelli. I just wanted to make sure I was cognizant of those things.
I mean, if you're at a breaking spot, we'll take a 10-minute break, but we're not going to break a whole lot. 10-minute works for me.
I don't want to break a whole lot. I'm cognizant of Miss Racanelli. That's all.
Well, we'll take a 10-minute break and then we'll come back.
Thank you, Judge.
Okay, I am back, and I think Ms. Racanelli is back, and so I think we're ready to go back on the record. Go ahead, Ms. Locke, pick up where you left off.
Thank you, Judge. All right. Ms. Whitaker, you recall that around this November incident, Mr. Whitaker sent you a text message regarding the incident. Is that right?
Yes.
I'm going to show you what's been marked as P41. And you see this text message, is that correct?
Yes.
And what was the date of this text message?
I believe this was the evening that the incident had happened, or early morning following.
Okay. And you've not changed or modified this in any way, is that right?
No.
All right, Judge, I moved to, one more question. Is this a true and correct copy of the text
Yes.
messages that, let me finish, that Mr. Whitaker sent you on this particular day?
Yes.
All right, Judge, I move to introduce P41.
No objection, Judge.
P41 is admitted.
And can you read the last paragraph of what Mr. Whitaker wrote to you?
I feel horrible for the way my actions have hurt you. I understand the paranoia, but there is nothing else. The past 3 weeks of punishment finally broke me. I did an unthinkable, insane act out of insecurity and loneliness. Please let me know how I can support you in the coming days. I would appreciate transparency in your intentions, and I will oblige. The last thing I want to do is make your life harder.
Did he ever tell you why he was recording you?
He didn't.
He never explained what the insane act out of insecurity and loneliness meant?
He didn't, I at this point didn't want a lot of, at this point I just wanted to sever the relationship, but he told me that, he was just curious, that he was lonely, that he just wanted to know, what I was doing. He
Okay.
didn't.
When was the next incident between you and Mr. Whitaker after he moved out that gave you some real concerns about his behavior?
I discovered that we were splitting custody of the children 50-50, and the children had iPads, and one of their iPads was logged into my Apple ID, and I discovered that he had changed the Find My Device
Objection, Your Honor. At a minimum, I'd like to voir dire the witness about what she says she knows he did.
Well, overruled on the objection.
All right. Ms. Whitaker, did you change the location finder on the children's iPads?
I did not change the location. I did not, no.
Did you change it to track your phone as opposed to the iPads?
I did not.
Okay. And to your knowledge, did anyone else have possession of the iPads other than Mr. Whitaker?
No, besides the children.
Okay. And the children at this time were what ages?
7. Desi might have been 3 or turning 4. I don't recall exactly. It was sometime in the spring of 2023. So, and then Julie would have been 1.
And did any of the children have any access to your passcodes that would have been allowed to make those changes?
No.
Okay. And so the iPads were changed to do what exactly, so the court's clear?
To track you have to choose which device the Find My Device will track, and on the iPads it was changed to my cell phone.
Okay. And why did that give you concerns?
It did give me concerns.
No, why?
Well, on the heels of discovering him with a camera in my bedroom window and reassuring me that there were no more tracking devices. And then there had been other just weird comments, things that he said and did that indicated he had some level of access to my whereabouts and ongoings. And so then I discovered that he was tracking my location with the kids' iPads. It was violating. It was, it was very concerning. You know, it's a violation, and this has been a theme of some of the other, you know, nonviolent issues in our marriage that we haven't discussed, is just crossing boundaries, invading my privacy, making me feel unsafe. That he had done that while we are at the same time, he's telling me how much he wants to cooperate and work together, what he's putting out there in text message, and what he's, you know, how he's presenting himself as a co-parent is very different than, you know, what he's doing behind the scenes.
And we'll get to that in a minute, but have there been incidences during this litigation where you've been have had concerns about his access to your personal information?
Yes.
Okay, and what have those concerns been?
A couple of them. For one, the supervisors, or there have been communications between us and the supervisors. And then immediately after, Rusty would send an email, just interesting timing of the context of the emails and the conversations that I was having with supervisors. Also, I'm sorry, I've lost my train
That's
of
okay.
thought.
Were there pictures that have come up in this that?
Yes. So some of the evidence that Mr. Whittaker has uploaded is things that could only have come from my devices, and I have multiple devices, and so I'm concerned because there are things that have come from multiple devices, not just one device, that he's uploaded as part of his evidence.
And were these devices that he should have had access to?
No.
Okay. Was there an incident with you and Mr. Whittaker in January of 2023 that gave you concern?
Yes, there was. He, at this point, this was after he had moved out. We had established a seemingly cooperative co-parenting and friendship arrangement. He asked me to go to a Broadway with him. That was something we always did in our marriage, so I agreed. On the way home from the Broadway, he shared with me that he was 100% confident that his diagnosis was sex addiction, sex and porn addiction.
And were you all, and just to give the court context, were you all having conversation? What were you all having in conversations about that particular issue came up in January of 2023?
Well, he was trying to get me to re-engage in the marriage. He was, you know, expressing that he was doing soul searching, that he had found Jesus, was going to get baptized at the church, and that, you know, I think it was an effort to keep me on the hook emotionally, to keep me giving him attention when he knew that I was done with the relationship.
And what did he tell you he was going to do in order to treat his porn addiction and sex addiction?
He was attending classes at the church weekly.
Okay. And did he tell you he had found a specific church group to attend?
Yes.
And what was that specific church group?
It was at Austin Ridge. I don't recall the name of the group, but Matthew Thigpen was the leader of the men's group.
Okay. And did he ever tell you what the focus of this particular group was about?
Sex addiction.
Okay. When he told you that he believed his diagnosis was a porn addict and a sex addict, did any of that come as a surprise to you?
It did, yes.
Okay. Tell the court why.
We didn't have a lot of sex in our marriage. It was the opposite. It was, you know, he would withhold sex and affection. He would, I felt like undeserving, I felt he tried to make me feel like I was undeserving of it. So he would withhold sex and affection in the marriage. So it was a shock to me that he said he was a sex addict because we weren't having sex. He wasn't addicted to sex with his wife. So
There, let me fast forward. When did Desi have her recital in 2023?
it was the weekend of May 21st, 2023.
Okay. And where were you scheduled to be that particular weekend?
One of my good friends was getting married in Colombia.
And Colombia, the country, or?
Yes.
Okay. And how long had this trip been planned?
It was, I think I decided in early April that I was gonna go. I don't recall exactly when, but I had discussed it with Rusty and said that I really wanted to go, and we agreed that I would go.
Okay. And what was the discussion with you and Mr. Whittaker with regards to Desi's recital?
We would, I would have to miss the recital, obviously, and so I was sad about that, and I wanted him to be at the recital as a parent supporting, but he said that he had a conflict as well and wouldn't be able to make her recital.
Okay. And what conflict did he tell you he had?
He said that he was going to a Tim Tebow revival conference.
Okay. And what did you understand that to be with regards to the Tim Tebow revival conference?
At the time, Rusty has always been enamored with, celebrities or, anybody who is in a high standing or has achieved significant things in life. He has role models. And so Tim Tebow is a football player. And he's also a Christian spokesperson who is fighting for, the world's MVPs, the most vulnerable people who are, he's fighting for, the impoverished. He's fighting for children who are being sex trafficked, who have been unidentified, and their images and videos sold on the dark web. We don't know who these children are. At the time when he told me that, I thought Tim Tebow was just some celebrity that he had latched onto, that he wanted to go to his conference because, I don't know, whatever, if it was helping him spiritually, great. I have since learned that Tim Tebow is also one of the world's biggest champions for children being sold online.
Okay. And where was that conference located at?
In Tennessee.
Okay. And to the best of your knowledge, did Mr. Whittaker go to at least a portion of that conference?
Yes.
All right. And were you all sharing joint bank accounts at that time?
No.
Okay. Did you have access to his bank accounts at that time?
Not at that time.
Okay. You have looked through the bank account statements that we received in discovery from Mr. Whittaker from around this time frame. Is that right?
Yes.
Okay. And when you were reviewing those bank records, and we'll show them in just a little bit, but when you were reviewing those bank records, what did you learn from looking at the bank records? With regards, let me be clear, with regards to that May 19th, May 20th, May 21st trip to Tim Tebow in Tennessee.
I saw the airfare. I saw that there was a Turo rental, a car rental. I saw that there were Wyndham hotel charges, I believe, from North Carolina. I saw that there were 2 Lyft trips.
And Lyft trips, only because I just don't remember. Do the Lyft trips tell you the location and pick up and drop off, or just show you the Lyft?
I don't believe it showed the location. But
And where were the Lyft transactions occurred? Did they occur in North Carolina?
yes.
Okay. And what is Turo?
Turo is a car rental service that you can rent people's sports cars, nice cars, whatever kind of car. It's a like a personal kind of like instead of renting from a enterprise, you rent it from a person who wants to rent out their vehicle.
Okay. And from your review of the records, did this match up with the location of where the alleged events occurred that he's been charged with?
Yes.
Okay. And I'm gonna open up the exhibit in just a second. And it's going to show you what's previously been produced by opposing counsel. Actually, let's see what it's marked as. 1 second, Judge, I'm sorry. I'll come back to that in just a second. I just can't find the exhibit numbers. Give me 1 second, Judge. All right. And so that incident occurred on May 20th of 2023. Is that your recollection?
I don't know exactly what date it occurred, but that's when the charges were, I believe, on the card. So
Okay. And he was arrested 11 days later?
yes.
Okay. I'm going to share what's been marked as P75 and P76. All right. And this is, the account number just so the court's clear has been redacted. This is the bank statement from Chase that we received in discovery from Mr. Whittaker. Is that right?
Yes.
All right. And well then, Judge, I'd actually just move to introduce P75.
I have no objection, Judge. Could I ask counsel to enlarge the screen?
I can try. I can't make any promises. Is that better?
P75 is admitted. If she can enlarge it, she can. She may not be able to. Zoom sometimes has a mind of its own.
I zoomed in, Mr. Kazin. Can you see it better now?
Yes, thank you very much. Appreciate it.
Let me try a little bit more. Sorry. I'll do my best. That's gonna be too big.
Yeah, there are plus and minus buttons. It'll do it real quick, but
And this actually shows the lift ride on 521, the lift ride on 522, Hampton's Inn in Charlotte, North Carolina. Is that right?
Yes, my apologies. I misspoke earlier. I said Wyndham. That was a different trip that he took. This was a Hampton Inn.
Okay. And the incident, and to your knowledge, is Charlotte, North Carolina, located in Mecklenburg County?
Yes.
Okay. And did he tell you he was going to Charlotte, North Carolina for any reason?
No.
Okay. And did he ever admit to you that he was in Charlotte, North Carolina during this time?
No.
Share P76. And this is P76. This is another account from Mr. Whittaker that he provided in discovery from, and it says Chase Sapphire account provided in discovery. So I'd move to introduce P76, Judge.
no objection, Judge.
P76 is admitted.
And this actually shows Miss Whittaker additional lift rides and an additional Wyndham charge in North Carolina during the time period in question. Is that correct?
I guess I didn't misspeak. It was a Wyndham.
Okay. And so he had 2 different hotel reservations in North Carolina during this time, is what it appears from your review of the records.
Yes.
And on 5/28, so May is 31 days, so 3 days before he is arrested, he makes a donation to who?
Center for Child Protection.
Had he ever made a donation, the best of your knowledge, to the Center for Child Protection before?
Yes.
Okay, and when was the last time you made a donation, to the best of your knowledge, to the Center for Child Protection?
Rusty was on the golf tournament committee. So I don't know if there were any donations made as a part of that, but we definitely attended the gala. I believe it was in 2021 that we went to the Center for Child Protection Gala together, and we made a donation at that point. It was an organization that it was one of our top organizations that we had on our list to put our support behind.
Okay. Did you find any actual charges for Tennessee on those statements?
No.
Did you find that curious?
Yes.
Let's talk about, you've heard Mr. Kazen's opening that quite frankly, Mr. Whittaker is a fantastic dad. You're asking the court for what with regards to the children?
I'm asking to limit their interaction and contact with their father at all costs.
Okay, tell the court why.
I feel that, I mean, as you can see from these bank records, like he said, he's going to attend Tebow Revival Conference. He says he's got Jesus in his heart. He made a donation to the Center for Child Protection. All the while, what he's actually doing, allegedly behind the scenes, is raping a child. I feel that Mr. Whittaker is a master storyteller and is great at crafting an image, and that the image is all an effort to disguise what he's really doing. The marriage is, I've learned a lot since being out of the marriage, how things work and how brainwashed I had been and how my actions were exacerbating the problem and not holding him accountable. And I feel that a lot of the niceties, the happy Father's Day, all the kind words, it's all an overcompensation for what's happening on the other end of the ping pong. I don't feel that a child saying, "I love daddy the most," makes somebody a good daddy. It makes somebody liked, but it doesn't make you a good daddy. I don't feel that a good dad would sacrifice his daughter's dance recital to go rape a child, or to even I don't feel that a good father does those things. I don't feel that a good father victimizes the one person who is left that's not incarcerated to care for the three children for the rest of their lives. I don't feel a good father.
I'm gonna object to narrative and ask for question by question.
Sustained. Sustained.
I'll ask the next question, Judge. Ms. Whittaker, and let's back up a little bit. Who's been caring for the children exclusively since June 1st of 2023?
Me.
Okay. And how often did, let me back up. So Mr. Whittaker was incarcerated until end of February 2024 and was out until he was rearrested in October. That's about right, correct?
Yes.
All right. And during the time that he was out, how often would he call you to check in on how the kids were doing or ask for updates on them?
So after he bailed out, and even before he bailed out, our communication had been pretty strong up until the middle of December. There was a lot going on as far as selling our home, selling his business, Christmas with the kids, the landlord at the rental. They were talking pretty frequently up to that point, and then there was almost no communication from the end of December until the time that he bailed out at the end of February. And then after he bailed out,
hang on. So let's back up. And you had a power of attorney, correct?
I did up until December 12th of 2023.
Okay.
24. Wait,
And
23.
that power of attorney allowed you to do what?
manage payments of bills. I was paying his rent and all of his bills. I was it was essentially like I was a widow and having to manage the estate completely alone. I was selling our home. I had all three children in my possession.
Objection
100
non-responsive. The question was, what does it allow you to do?
Sustained.
Okay. And so you ran basically the marital estate under that power of attorney.
Yes.
Okay. And so when you ran the estate, were you responsible for the sale of the house?
Yes.
Okay. And did anyone from his family help you with the sale of the house?
With the sale of the house, Dusty and Rebecca Whittaker did help me with some moving at the end. And then after the power of attorney was revoked, Dusty became the power of attorney for Rusty, and he helped with finalizing. We actually closed on the house, I believe, January 5th of 2024. So he signed the final documents.
And when did you all sell his business?
That was so after his arrest, his company was notified of his charges, and being the nature of the charges, they were going to involuntarily terminate him within
Objection
14 days.
non-responsive. The question was, when was the business sold?
That's fine, Judge. Ms. Whittaker, it's
So
really sorry. I need for you to listen to my question. Just answer what is asked. When do you recall the close of the sale occurring for the business?
We signed a promissory note. I don't know if this would technically be the sale of the business, but Yuri McBride was the buyer, and he and I both signed documents on June 14th of 2023. That was it allowed for a lot of flexibility with a look back period, a formal valuation, but it was a loose contract. I don't know if you would consider it the final contract, but there was a document executed on June 14th, because had that not happened, the business would have been involuntarily terminated and would have been zero.
All right, so let's talk a little bit about the business. When did Mr. Whittaker lose his license to practice his investment business?
I was made aware that he lost his license, or that his license was suspended. I believe it was in August of 2023 when the CFP board imposed those suspensions on him.
Okay. When was and what was the name of this business?
So Rusty's business was Whittaker Private Wealth. He worked under an organization, Genesis Wealth Management, and then the parent company for Genesis was LPL and FRG. I'm not sure exactly the structure of how everything works, but they're independent financial advisors, and they operate with different platforms and under groups that kind of gather together for marketing and information sharing.
Okay, when was Whittaker Private Wealth founded?
I don't actually know. Sometime after the filing for divorce, I believe it was in 2019 or 2020, Rusty restructured his business.
Okay, what was the business before?
I don't know that he had an LLC before. I think he was just using his name. I don't really know.
Okay, but the actual business itself that was sold was created during the marriage. Is that your understanding?
Yes.
All right. And so were you required to sell? Were you and Mr. Whittaker required to sell the business pretty quickly after his arrest?
Objection leading, facts not in evidence.
Sustained. Rephrase or ask a different question.
Sure. Did Mr. Whittaker ask you to help with selling the business?
Yes.
Okay. And did Mr. Whittaker tell you why you had to sell the business?
Because he was incarcerated and could no longer practice.
Okay. And so what did you have to do in order to facilitate the sale of the business?
I had to find a buyer who was willing to take the business of in such a kind of uncomfortable scenario. And I had to execute the documents within 14 days.
And what was your understanding of what would happen if those documents were not executed within 14 days?
That all of Rusty's clients would be dispersed among different LPL advisors, and our value for the business would be nothing.
All right. And you all actually received, and this was produced by Mr. Whittaker in Discovery, the valuation of the business. And do you recall looking at this market value and summary of the value of the business?
Yes.
All right. Judge, I'd move to introduce P23.
P23 is
Counsel-
admitted. Oh, you do have something. Okay, I was waiting.
I was just gonna say, counsel, could you scroll to the bottom so I can see the Bates?
I better find, I don't think this one has your Bates. This one's we supplemented, but I'll find the Bates labels for you if you want.
Okay.
Give me 1 second to get the Bates labels. And I'll come back to that exhibit in just a second, Judge. As soon as I get the Bates labels. How much did the business sell for?
I don't know the final amount because my power of attorney was revoked before the look back period was completed, and I believe it was either Dusty or Rusty that actually executed the final documents, but it was negotiated at about 1.8 million to Uri, pending a look back of assets that departed during that 6-month period.
All right, I'm gonna show you what's been marked as P29, which is the amended and restated purchase and sale agreement for the Whittaker Private Wealth LLC. Do you recall this?
Yes.
And this was effective as of June 14th, 2023. Is this a true and correct copy of the final agreement?
This is not the final agreement. I believe this is the agreement that Uri and I signed on June 14th of 2023.
Okay. And this was the first agreement that you all signed that started the whole process. Is that correct?
Yes, I believe so.
And it talks about the promissory note. And was the promissory note actually executed on this particular day, June 14th, 2023?
No,
When was the promissory note executed?
I don't know exactly the date. It was after my power of attorney was revoked, but we did not get a payment from the business until early 2024.
Okay. And you've not changed or modified this final amended and restated compiled and conformed document, correct?
Correct.
This is a true and correct copy of what you received.
Yes.
Judge, I move to introduce P29.
No objection, Judge.
29 is admitted.
Do you recall, Ms. Whittaker, what the first payment was?
I don't.
Okay, but that's the one that went into the attorney's trust accounts, is that right?
Correct. Yes.
All right, let's show the court. Oh, and Mr. Kazin, your Bates number on my previous P23 is Whittaker 300160. So I would move to reintroduce and I'll share the screen, P23.
I think I may have already admitted it. I don't know what Ms. Racanelli took down, but P23 is admitted.
Thank you. And to go back to this actually, the range of value, Ms. Whittaker, was what for the business?
The low end was 2.18 or 2.018 million. The high valuation was 2.825 million.
Okay. And you sold it for well under that, is that right?
Yes.
Okay. And why do you believe you had to sell it for less than the market value?
Because it was sold under duress. It was it was something that needed to happen quickly. The buyer was not prepared to take on new clients of that size. He didn't have the infrastructure to support it. There was a lot of stigma around the reason for the arrest and what the messaging would be to the clients and whether or not they would choose to keep their assets with Uri. First of all, going to a new advisor, people, there tends to be some attrition, even in the best of cases, with a smooth transition. But in this case, Rusty was arrested for 6 felony charges involving sexual misconduct with a child. And Uri was concerned about the client's reactions to such news and wanting to separate from the ugliness of it.
Okay. And just to clear up some other housekeeping, you recall that we served requests for admissions on Mr. Whittaker, is that correct?
Yes.
All right, and these are his actual responses to the request for admissions, is that right?
I believe so, yes.
Okay. And we've not changed or modified, this is actually what we received from him, is that right?
Right.
All right. And then a fair amount of these, he actually pleads the fifth, is that correct?
Yes.
Judge, I move to introduce P19.
I don't have an objection to that, Judge.
19 is admitted.
Thank you. P18, we also served on Mr. Whittaker, written interrogatories. Do you recall that, Ms. Whittaker?
Yes.
And these are his answers and objections to written interrogatories. Do you recall receiving these?
Yes.
Would you agree with me that we've not changed or modified what we received from him with regards to responses back in July of 2024?
Yes.
All right. And in here, he also pleads the fifth to several of the questions. Is that correct?
Yes.
All right. Judge, I move to introduce P18.
No objection, Judge.
18 is admitted.
Thank you. All right. Let's go to the spreadsheet. We created an amended spreadsheet in this case that included all of the current values in this, in your case, correct?
I believe so, yes.
All right, let me see if I can pull it up. And while we're other things, I'm going to show you what's been marked as P24, which was Mr. Whittaker's W2. This shows the wages and tips and compensation that Mr. Whittaker had for 2023. Is that right?
I believe so, yes.
Well, this is a true and correct copy of his W2 and tax statement for 2023, correct?
Yes.
All right, Judge, I move to introduce our P24.
P24, I don't object.
P24 is admitted.
Was this 309,000 approximately what he made annually?
No, in 2023, he only worked through his arrest on June 1st, so this would have been 5 months of wages.
Okay. And how much did he typically make prior to the arrest?
His business was growing. I think he was on track to make $1 million for 2023.
Okay. Okay, I'll have to come back to the spreadsheet. You communicated with Mr. Whittaker through text while he was in jail, is that right?
Yes.
Okay, and how did you all communicate? Like the text message app?
Yeah, there was an app called GTL app, as well as phone calls. We talked on the phone quite a bit.
Okay, and I'm going to show what's been marked, and we'll get to some of those messages in just a minute. But P37 is just you and the kids, a compilation of photos. And you've not changed or modified these photos in any way.
Other than filters, no.
Okay, but we all use filters, but other than filters, do they accurately represent you and the kids?
Yes.
Okay, and Judge, I move to introduce P37.
No objection, Judge.
P37's admitted.
All right, and so the court knows who is who. This one is who?
The small one in the front is Juliet,
Okay.
and
Back.
the one behind her is Desiree.
You call her Desi and Julie, right?
Yes,
All right. And would that be Weston?
that's Weston.
Okay. How are they doing right now?
That is, it's not an easy question to answer, but I'd say that, given the circumstances, they're doing phenomenally.
Okay. Do you believe that, let me back up. When Mr. Whittaker was in Travis County Jail, were you allowed to send him pictures of the children through that texting app?
No,
What would happen every time you would try to send him pictures of the children through that texting app?
they would get rejected.
Okay. And what would happen when you would try to put the children on the phone with Mr. Whittaker while on phone calls while he's in Travis County Jail?
So the video calls were not allowed. I was not allowed to put them on the video. The phone calls was against the rules, but we did it anyway.
Okay. And how often now is he talking to the children?
Approximately 2 times per week for 30 minutes on Thursdays and an hour and a half on Sundays. However, since his most recent arrest, there's been some lapses in, understanding his situation and setting up the accounts and things. So it hasn't been quite so much since his federal arrest.
Have you been able to work out communication issues with Mr. Whittaker without the assistance of counsel?
No.
Okay. And what are the problems that have arisen during these communications?
Rusty has been extremely rigid in the timing and the environments of the calls. He doesn't want calls to be conducted while anyone is eating any snacks. He doesn't want there to be any outside conversations or noise in the room. Not multiple kids at a time. Basically, he wants us to sit in silence while each kid has their individual turn, which is next to impossible to do as a single mother of 3 young children and the sole provider. So it's been difficult because he's objected to many circumstances.
And what are some of your concerns about what he is doing while on the phone with the children with regards to his request for information?
I feel he is, the things that he's asking the kids for are to obtain information about our whereabouts, our routines, the people that we spend time with, knowing that I'm uncomfortable with it.
And you have heard the request that they want the children to go to whatever facility he's at with Dusty to go see him. You know that request?
Yes.
Why do you believe that is not in the children's best interests?
There's going to be significant trauma that they experience as a result of having an incarcerated father, and then especially when the nature of the charges are brought to light. I don't feel that it is safe or healthy for my children to be exposed to, inmates in prison at their ages. My understanding is also in federal prisons that the child sex related criminals are gathered together in a specific type of facility, and that visitation is commingled with other convicted predators. And I am absolutely not comfortable exposing my children, putting children in the presence of other child predators. Aside from just sending them up to see their father behind glass, I think that's traumatic in and of itself. But then when you factor in the nature of the charges, you factor in the environment and the others that will be around, and that their mother, the sole person who's been caring for them for a year and a half now, is not going to be there. I'm absolutely not okay with it.
Are you okay with Mr. Dusty Whittaker traveling with the children without you being present?
No.
Okay, why is that?
Frankly, I'm not even comfortable myself traveling with my own 3 children alone on an airplane, much less somebody who barely knows them and hasn't seen them for 6 to 8 months at all, and very little prior to that, because I've been isolated from the family throughout this process.
Let's go over finances. So we have attorney's trust accounts are holding between Mr. Kazan's office and my office a fair amount of the funds from the proceeds of the business sale and the house sale. Is that your understanding?
Yes.
All right, so I'm gonna show you what's been marked as P31, which is the trust account balance that was originally at Candace Darley, but it was eventually transferred over to David Kazan. You recall this, correct?
Yes.
All right, move to introduce P31.
No objection.
P31 is admitted.
P33 is the current account balance from Mr. Whittaker from Mr. Kazan's office after it was transferred from Mr. Whittaker's prior attorney, and this shows the current balance as of at least, well, there have been no withdrawals since 11/7 of this year. Is that your recollection, Ms.
I
Whittaker?
believe so, yes.
All right, I move to introduce P33.
No objection, Judge.
33 is admitted.
All right, thank you. I'm going to show you what's been marked as P27, which are the funds held at Coldwell Bowes. And there's been no deductions from these since this was printed out. So I'd move to introduce P27.
No objection.
P27 is admitted.
Thank you. What are you asking the court to do with regards to all of, well, let me back up a little bit. Are there taxes still owed?
Yes.
All right, let's talk to the court about the taxes. What taxes are still owed to the best of your knowledge?
I believe there have not been any taxes paid on any of the proceeds from the sale of the business. And I don't know whether there will be taxes that need to be paid on the sale of the home.
Okay. Are you asking the court to set aside a certain portion of this to cover taxes before any other distributions are made between you and Mr. Whittaker?
Yes.
Okay. And do you think setting aside approximately 30% for right now would be enough to cover whatever the outstanding tax liability may be?
I believe that's the number we've been working with. Yes.
Okay. And if there's any funds remaining, are you asking that you be awarded them 100%?
Yes.
Okay. And why do you think that is a just and right division of the marital estate?
I am a couple of reasons. For one, I am the now sole caretaker of 3 very young children, and I am parent number 1 and parent number 2 for these children, and have been for 18 months. I'm the sole emotional, physical, financial caretaker for 3 children for the foreseeable future, likely for the remainder of my children's life under my roof until they emancipate. Rusty's charges, as I understand it, carry a minimum mandatory sentence of 10 years for 2 of the charges that he's facing, with a max of life in prison. This business was started while we were still married, or while we were married, and therefore I'm entitled to half of the business as it is. I worked tirelessly grew, birthed and breastfed 3 babies while maintaining a very stressful career so that Rusty had the means and freedom to start his business while we were married and I was raising and growing children. I am now going to be responsible for them in entirety, and we've been forced to sell, an asset that we were building during the marriage that I was relying upon to be able to support our children.
What had you and Mr. Whittaker projected as to be his income in the future had he not been arrested?
Well, Rusty was I believe he was on like a 10x growth plan with his entrepreneurship company that he was a part of. So he was definitely had big goals in mind for growing his business. And I don't know, what the ultimate value of the business was, what his ultimate, he's growth minded. He's always wanting to grow. So
And him being locked up and not able to, I guess, earn until whatever happens with these charges has impacted your children to some extent.
Well, absolutely. I mean, we sold the business and now it's a finite pool of resources that is draining rapidly as a result of, in my opinion, unnecessary attorney fees and hearings. And this is what I'm dependent on to be able to care for my children for the foreseeable future, because not only am I parent number 1 and parent number 2 and the only person who has been contributing to the estate since June of 2023, I'm also limited in the work that I can do, the job that I had before. Some of the conflict in the marriage was due to me working and not being home because I was working. And so the job to earn what I've traditionally earned requires a lot of time away from the home, a lot of mental stress and focus that I don't have the capacity for right now. And
in fact, we have a recording of Mr. Whittaker cursing at you because you had gotten home a little bit late from work. Do you recall that?
yes.
Okay. And was this typical behavior of him when he was angry with you?
Yes.
And do you recall the date of this recording?
I don't recall the exact date.
Do you remember the year?
I believe it was 2020.
Okay. And you've been working, just remind the court, for this company for how long?
Almost 10 years.
Okay. And do you recall in 2020 when you made this recording of him cursing at you, which children did you have at home?
Desiree. I think Desiree for sure. I can't see the video, so I don't know where Weston was, but definitely Desiree's in the video.
Okay. And can you just, before we play it, can you describe, let me back up. Have you changed or modified that audio clip in any way?
No.
Or it's a video clip. Have you changed or modified in any way?
No.
Okay. It's a true and accurate copy of what you recorded back in 2020, evidencing Mr. Whittaker's behavior towards you. Is that right?
Yes.
Okay. And can you tell the court how often would he engage in this type of behavior towards you?
It was frequent. We were constantly walking on eggshells.
And just because frequent has different terms for everyone, what does frequent mean to you?
We would go through phases. So it's not like it happened every day, but there were periods of time where it was happening every day. And then there were periods of time where it wasn't happening. So, I would say probably once a week, there would be some escalating event on a regular happy week. And then when things were not good or when there was an argument, the arguments didn't resolve in a timely fashion like most arguments do. The arguments would drag out for weeks, sometimes months. And then during those unresolved periods of time, there would be frequent, just escalations, raising voices.
How often would Mr. Whittaker engage in the silent treatment with you?
Every time we had a fight.
Okay. And how long would those periods of silent treatment last on average with Mr. Whittaker?
The first time we had a big fight and there was a silent treatment, it was over 8 weeks.
Okay. Was that the longest one?
I believe so. Like
And
that, yes.
When was that?
That was in 2017.
And how often would Mr. Whittaker, since 2017, give you the silent treatment?
On average, we had like really big separation events every 9 to 18 months. It was cyclical. There would be a cycle of happy times, and then tension building, and then a big blow up event, and then a period of isolation and silent treatment, and then desperation to figure it out. And a couple times filings for divorce, a couple times we were able to get in with therapists. Just kind of depends on the situation. But
All right, Judge,
how
I
it
would
goes.
like permission to play P73, which is the recording.
Judge, I have an objection to the foundation. I don't think the mere year is good enough for the time frame of the recording, but more precisely, it's my understanding that the recording has in fact been edited to remove Ms. Whitaker's portion of it, and I would like to voir dire her about that before you consider playing the recording.
Any response to that?
I do. The rules of evidence are designed to ensure that authentic information is admitted. It doesn't say anywhere in the rules you have to actually have the specific date and time that something was recorded. It goes to the authenticity and to the weight of the credibility. And
So right now you're just playing it, and the court has to make a legal call. So I'm not going to stop the playing. I'm not admitting it yet. So play it and I'll make a judgment call about admissibility.
yes, Your Honor. Let me share screen.
I don't have audio.
I can hear it. I don't know. Quick question. Can anyone hear it?
No.
Judge, I'll come back with that after the lunch break once I figure out the
right.
audio portion on Zoom, because it just may be a technical input problem on my end. We're at a good stopping point if the court wants, with 3 minutes before 11:30.
Sure, that works. I just want everybody to be cognizant of time. I think, unless I hear differently from the jail in Mecklenburg County, we're just going to get started in an hour. So we'll take a relatively short lunch break. I saw Mr. Whittaker give a sign. Yes.
Your Honor, I can speak to that. I have complete flexibility today, so I don't expect any changes from the jail.
Okay, so then that's what we'll do. We'll break now at 11:30, and then we'll come back and get started at 12:30, or Eastern Standard Time. I think it's 12:30, and we'll get started at 1:30. I think I'm doing that right. And so I'll see everybody back in an hour. Thank you.
Thank you.